Every state has what's called a statute of limitations. The statute of limitations dictates the amount of time that a plaintiff has in order to file a lawsuit. These can be complicated questions of fact that require diligent inspection, investigation by lawyers and experts in order to ultimately answer this question. However, in general, the statute of limitations for premises liability claims in Ohio is 2 years. This is not a strict rule in the sense that there are exceptions to the rule. However, the failure to file within the applicable 2-year period will result in a bar of the claim. One of the big exceptions to the 2 years, 2 years from the date of the injury, would be what we call the discovery rule. The discovery rule allows a plaintiff to have 2 years from not only the date of the injury, but the date that they connect the injury to the third party's conduct. An example of this would be if a individual is diagnosed with a particular form of cancer, such as mesothelioma, that would be related to asbestos exposure. While the exposure may have occurred many years ago and the injury started many years ago, the diagnosis was only recently, and the connection has only been made recently between the diagnosis and the form of exposure. Under those circumstances, the statute of limitations would be 2 years from the date of the diagnosis. Therefore, it's critical that if you believe that you've been injured due to the defective condition of a property or premises liability, it's imperative that you contact a lawyer at the earliest state of the case so that there's sufficient time in order to protect the 2-year statute of limitations in Ohio.